Good afternoon, everyone. Thank you for joining us. We're kind of opening up the gates, let everybody in and get settled. Check your computer, make sure that your audio is muted and whatnot, so we don't have a lot of background noise. And I think we can probably do that on our end as well if we want to mute you. We'll get started here in just a moment. I'm going to give another minute or two and let any other attendees hop on as they do. All right, that's probably enough time. If they're running late, then they're running late. They'll miss this part. Thank you very much for joining us today. Welcome, everybody. My name is John Barine. You may notice that my elder counterpart is not with us today. Steve had a meeting get scheduled. It was really either today at noon or like May 2024. So he had to jump to that. But fortunately, we've found ourselves a replacement Steve. It's actually a replacement Steve B. We've got Steve Brown and Brian Taylor leading our conversation today. Steve Brown is a longtime practicing attorney in Colorado. He's been in practice over 30 years, Cherry Creek, Denver Tech Center, Parker area. So he keeps working his way south. I think he's headed to the Springs next. But he's been doing this for a real long time, been in Parker for 15 years on its own. Brian Taylor has been working with him for 8 years. Brian's actually Steve's son-in-law. He stole away Steve's eldest daughter and repaid him with 3 grandchildren, a 5-year-old, a 3-year-old, and a 6-month-old. So Brian and I get to commiserate about being tired a lot. But Steve and Brian have been great resources for our clients for many years. They're excellent gentlemen. They've really helped serve our clients in many ways over the years. So we're delighted to have them with us. Thank you, guys. Couple of housekeeping items, format wise for our time today. We kind of budgeted about a 45-minute window. Roughly 30 minutes of that will be a presentation, education, talking through some of that. And then we've got about 15 minutes or so budgeted for some questions. Speaking of questions, if you have them, use the chat feature inside of Zoom. It should be, I think there's a button on the bottom part of the screen. Hit that chat feature and tag me when you chat that in. So send it to John, and then I'll compile those questions. I'm sure there'll be some duplicates. We'll field most of those at the end, and if anything's topical as these guys are going through, then I'll pop on and field that question or offer that question up as they're going. So that's kind of what our it looks like. Steve and Brian, we'll pass over the reins to you guys. Thank you again for being here, and I hope it's a wonderful time for everyone.
Thank you, John, for having us. It's a pleasure to be able to work with Prosperion and the interest that your clients are showing in some basic estate planning information. So my hope for this time is that maybe you all have a pen and paper there, and that you will have 1 or 2 or maybe more takeaways for estate planning for yourselves, where you will find value in needing to maybe update a beneficiary designation, maybe update an estate plan that you have, maybe getting documents in place that you don't have, or maybe just confirming that what you have is what you need, and that'll give you and your family some peace of mind. So we have a number of slides that we're going to go through on basic estate planning documents and concepts. We will have questions, as John mentioned, so hopefully this will be informative for you. Let's get started. Estate planning misconceptions. These are some of the questions that we hope to answer. There are more that are possible misconceptions that we hear. What happens if you don't have a will? Will the government take your assets? Can I use the DIY? Do it yourself approach to estate planning documents, or go online and try to find documents to meet your needs. We'll talk about that a little. If you put your assets in a revocable trust, are you protected from creditors? Common question we hear. If I have a will, does that mean that my estate will not go through probate? We're going to answer all of these as we go. When I start, I think all of us need 4 main documents in our estate plan, at a minimum. The first is a will, and that could be a will / or a trust, depending on what your estate plan looks like and what your needs are. Let's start with a will. Next is a living will, and we will explain all of these in more detail as we go. The third is a medical durable power of attorney, and the fourth is a general durable power of attorney. We refer to that also as a financial power of attorney. So let's start with a will. Why do we need a will? And what happens if you die without one? Well, the reason for a will is so that you can appoint an executor or a personal representative and provide a distribution plan for your estate when you die. You're setting that forth in a document that your heirs can read and understand and avoid uncertainty and avoid court. Picture on the left, avoid disputes, as you can see the picture there, or involvement by the court. None of us wants involvement after we die by the courts. We want our estates handled by our families and in accordance with, hopefully, a will that we have in place. By the way, if you die without a will, there are statutes that take over that will determine where your estate goes. And that may work for you or it may not. In many cases, it doesn't. And without a personal representative nominated, which is also known as an executor, without that in your will, it makes it more difficult for a person to do simple administration of a person's estate after they die. And that's even if things pass outside of your will, by naming beneficiaries on life insurance, for example. A lot of times, financial institutions and others need to hear from a personal representative, even if it's not a probate. We'll get more into that. Let's start with a simple will. So if it's a married couple, which most of our clients are, then a simple will would say one of us dies, everything goes to the survivor. And that's pretty straightforward. And then you add kids to the picture. If they're adult children, everything goes to the 3 kids in this case in equal shares. And we also provide that if one of the kids were to predecease mom and dad, that their share, their 1/3 share in this example, would go to the grandkids from that deceased child. I saw the house pop up. All right, the house is usually owned in joint tenancy between husband and wife in this example. And in a simple will situation, that would pass to the surviving spouse as a matter of law. And then the will would say that it goes to the 3 kids after you die. We will talk about the possibility of naming a beneficiary on a residence, on a home, such as the 3 kids after mom and dad died, and that's called a beneficiary deed. IRAs, retirement accounts, are normally owned just by one spouse or one person, and then that person names the beneficiary on that account. That is far preferable to having it go to a person's estate when they die. It's important, if you have IRAs, 401ks, and the like, that you have named beneficiaries. If you're married, your primary beneficiary is presumably your spouse. And then you want contingent beneficiaries naming the 3 children. And when you work with your financial institution, ask them about this Latin term per stirpes, which provides that if one of your kids were to die, that their 1/3 share would go to their kids. And that's a box that you normally want to check when you're naming beneficiaries. Need to be careful in naming beneficiaries. They've made it a lot easier to just do online. Sometimes that's good, sometimes that can get you in trouble. So make sure you work with your financial advisor to discuss the proper way to name beneficiaries on things like IRAs. Life insurance, the same way. You'll need to work with your insurance company to name beneficiaries. There is a value to naming beneficiaries on life insurance and to having a home passed by joint tenancy to a surviving spouse. And that value is with those two assets, as well as the IRA, if they don't go to your estate, but they pass by ways I just mentioned, they're exempt from creditors. And that's a nice thing to know with those three assets that are pictured. Tangible personal property, vehicles, jewelry, china, heirlooms, artwork, those types of things can all be easily passed by what's called a tangible personal property memorandum that each will has. And that's where a person can say, I want my car to go to this child, or I want this piece of jewelry or artwork to go to this person. That can be changed easily without attorney involvement. Once you have a will in place, you can change that on your own. Have it signed and dated. It does not need to be witnessed or notarized. It only works, though, for tangible personal property. Doesn't work for any monetary accounts that you have. Doesn't work for real estate. Doesn't work for stock. But it's a nice feature, and sometimes it's a very important feature because we find that some of the biggest disputes or problems after a person dies is with the stuff. It's with the household goods. And that's a shame because they're of the least value usually. Bank accounts. Often bank accounts between spouses in a simple will approach like we have are owned jointly, and they pass to the surviving spouse. If you want to possibly avoid probate, and we'll talk about probate, it might be worthwhile to have what's called a TOD on a brokerage account, for example. TOD, you can write that down if you'd like, stands for transfer on death. Bank accounts have a slightly different terminology if you want to name a beneficiary on it, and that would be a POD, pay on death. Same as the TOD, just different terminology for different types of accounts. Those are possibilities for naming beneficiaries on your financial accounts. So moving out of the simple will category, we're now into will with trusts for spouse or kids. Let's talk about kids first. If you have parents with minor children, probably the most important reason to have a will for any of us or them in that situation is so that in the will, they're appointing a guardian for the kids should something happen to mom and dad. Guardian appointment is very difficult, and that's often what causes young people to not fill out a will because they know no one can raise my kids like I do. So it just causes them to postpone what they really need to do, and that is appoint a guardian or co-guardians for the kids to raise them should something happen to mom and dad. The other problem with this is those who need the wills the most are at a stage of life where they probably have the least money. I'm guessing that most of you listening to this presentation are beyond the stage where you have minor children. And you are in a situation where you can more easily afford to pay for wills and powers of attorney and trusts and so on. We don't need it as much as our kids do. So that's something to think about and possibly helping them through that so it doesn't create a hardship for you as the parents either. And the other component to a will with minor children is to have the assets of mom and dad go into a trust for these young kids. Otherwise, if you don't have that set up, your kids, when they turn 18, will have a right to their share of their inheritance. And with life insurance and IRAs and investments and all that we have, that could be substantial. And we all know that a young person at 18 probably shouldn't get $1 million or $500,000 or whatever it is that they would get. And it might be wise to put it into trust. A trust that would, for example, meet their needs by a trustee that you would appoint. Could be the same person as a guardian, could be another sibling or person to manage the money, make decisions, know your kids, decide what are their needs? What do we pay the guardian to raise these kids? How much do we pay for education? If a child wants to get married, how much do we pay for that? They want to buy a car, start a business. Those are all things that a trustee will need to make a decision about in raising these kids. There are usually payouts, mandatory payouts that we build into a trust like that for the kids. For example, when a child turns 25, maybe they would get a third of what's in their trust. We choose 25 because it's usually after college education, having to get a job. And so before we give them a big chunk of money, let's get a little responsibility under their belt. Maybe they get married. We don't want them getting married for the wrong reasons, or someone marrying them for the wrong reasons because they have a lot of money and are driving a nice car rent. Then we would have a second payout, perhaps at age 25, where we get the child would get half of what's remaining in their trust. And then it would pay out maybe at 30. Those are examples, and they're fluid. They change depending on, you'd have to change your will, but the responsibility of your kids and the size of your estate and what everybody's comfortable with. Okay. The problems in not having the will that I'm talking about is if you don't choose a guardian in your will, or if your kids don't choose guardians for their kids in their wills, the courts then have to do that. And you may have people fighting, family members from each side of the family deciding they're the best choice for guardian. There may be a lot of money in the estate which would color someone's desire to be the guardian and have access to that money to raise these kids. You can avoid these problems by having estate planning documents in place. There are also wills for special circumstances. If there's a child that has, or a person that has special needs, like they're on maybe SSI or SSDI, Social Security Disability, if they're getting those benefits and they inherit money, then that money is going to go to the government and suspend the payment of benefits. There are trusts out there called special needs trusts or supplemental needs trusts that can be drafted to provide money to meet a person's needs that will shelter that from the government. Blended family planning. This is becoming more and more common. And by blended family, I mean second marriages with kids from former marriages all blended together. How do we create an estate plan that provides for new spouse, but yet also preserves assets for children from a former marriage? That can be challenging, but we have different tools that we use to deal with blended families. Everything from premarital or prenuptial agreements to postnuptial agreements to agreements on IRAs and trusts. So, gift and estate tax matters. There's a lot of talk about gift tax and estate tax. And the reason why is most of us really don't want to pay the government anything from our estate when we die. Federal estate tax has been changing over the years. And what there is in federal estate tax is this concept of an exemption amount. First of all, between spouses, if a person dies, there's no federal estate tax. You can pass an unlimited amount of your estate, of your assets to your spouse without any federal estate tax. So there is a benefit to being married. However, when the second person dies, or if you're a single person and you die, you have a limit on what you can pass to a non-spouse before the government starts charging tax on that. And currently that limit is very high, and it's higher than most of us even need to think about or worry about. And in the slide, you'll see it's $12 million. So a person now, a single person or a surviving spouse, can pass on to kids or anyone else and up to $12 million. After that $12 million, the tax is about 40%. Now you can give to charity and there's no tax. But that $12 million is subject to change. First of all, the current Biden administration has talked about changing that to $5 million. In the year 2006, this $12 million adjusted for inflation amount sunsets, which means it goes away and it goes back to 5 million. One more thing to understand about estate tax is if it's at 5 million and you add your life insurance and your equity in your home and your IRAs, you're starting to get where more people are close to having to pay federal estate tax. So it's something to understand that there is this exemption amount out there. It's something to keep track of so that you can look at your estate and decide, do I need to take special measures to deal with federal estate tax in the future? Whereas today, most of us don't need to. I'll just briefly mention, if you go back to that slide, there's a technique of creating a family trust when the first spouse dies. Your will has to have that in place when the first of you dies in order to take advantage of a measure to lower or eliminate federal estate tax. Annual gift amounts, let's talk about that too. People often say, how much can I give my kids without having a tax consequence? Well, that amount is currently $16,000 per person per year, which means if you have a child, you can give them $16,000 a year. You and your spouse can double that. If your child is married, you can double it again. So there is a way to give substantial amounts of money to children, especially if they're married and if you're married, by without having any gift tax return to be filed or tax issues to be concerned with. All right, let's go to probate. In Colorado, we have a lot of people moving here from California. And California is a state that's much different than Colorado regarding this concept of probate. In California, probate is very unpleasant, expensive, time-consuming, and to be avoided at all costs, I'm told. I'm not licensed in California. People in California all have trusts to own their assets so they don't go through probate. So what is probate? Probate is a legal proceeding. It's a legal proceeding with the court to administer an estate. So if you have a last will and testament as pictured in this slide, what happens is if a person dies and probate is necessary, we apply to the court to have a personal representative or executor appointed to administer a person's estate. By administer the estate, I mean they can sign deeds to transfer property, they can go to banks and transfer money that's in an estate, and that's the purpose of having a personal representative appointed. Part of that process is publishing this appointment as a notice to creditors. And so we publish it in a small local newspaper saying so-and-so has been appointed personal representative of this estate. If you have any claims against this estate, you need to bring them within 4 months from the date of this publication. And if you don't bring them, your claims are barred. So that is an advantage to probate in doing this notice to creditors, because without that notice to creditors, creditors have a year to bring a claim against an estate. After a year, all claims are barred. So that is one advantage to probate. After the notice to creditors and the administration of the estate, which is paying bills, doing burial instructions, filing tax returns, closing accounts, retitling accounts, we make distribution of money in the end. That is the process of probate. Now, let me say a couple of more things about it. First, you can write this down. Colorado is a probate-friendly state, whereas California is not. Other states are not. Some are, some aren't. By probate-friendly, what I mean by that is it's an informal proceeding. It's an administrative proceeding. It's something that we meet with clients to fill out documents. We file them from our computers with the court from our office. We don't go to court generally on an informal probate. It doesn't take that long. It doesn't tie up assets for a long time, and it doesn't provide money to credit to the government that you wouldn't otherwise pay. So there are a lot of rumors or concerns with probate that I think are frankly unfounded. However, with respect to probate, if you can avoid probate by taking reasonable measures and still accomplish the goals of your estate plan, yes, let's avoid probate. Would you go back to probate for a minute? How do we avoid probate? Well, when a husband and wife are married, you generally do avoid probate because most of your assets are either joint or you've named each other as a beneficiary. And so you avoid probate when one of the spouses dies because everything just passes to the surviving spouse as a matter of law. It can pass to kids and avoid probate as well by naming beneficiaries or contingent beneficiaries on certain assets, or by doing what's called a beneficiary deed on a home. That might be something I could talk about now, is a beneficiary deed. It's a relatively new concept, and it's in some cases, it's an extremely valuable tool to avoid probate. And that is, if you own a home, mom and dad, and then one of you dies, it becomes a survivors by joint tenancy. And then the second dies, if you have recorded a beneficiary deed that says, when I die, this goes to my two children, then when you die, your children just need to record a death certificate for you and your spouse, and the county assessor will retitle that property in the children's names. So that can be a good idea to avoid probate with a home. It can be a really bad idea if you're giving it to two kids that are estranged, that can't make joint decisions, that would create a hornet's nest and further estrangement in your family. So before you run out and fill out a beneficiary deed, and I wouldn't fill it out on your own either. Let me talk about that one. That gets into the do it on your own approach. We have a lot of business in our office from people who have tried to do deeds on their own. They do quick claim deeds, and they call them quick claim deeds because they don't understand how to say the right term, and they just fill them out and record them. And they are called quick claim deeds, and that's not always the best deed to use. It's a deed that transfers homes or property to a spouse, to kids, to whomever. And there are a lot of pitfalls in executing legal deeds on properties. Oftentimes people use the wrong legal description, or they don't get the names right. They use middle names versus not using middle names. They don't use a joint tenancy deed versus a tenants in common deed. These are different types of deeds. And so I don't recommend that you go to a forms store and try to fill out your own deed and transfer real property. Another caution while I'm thinking about it is we're talking about transferring a residence to kids on the death of mom and dad. Well, sometimes I get clients that come to me, and it's usually mom's the only one left. She's old. She's trying to make it easy on the kids. So she says, let me just deed the home to the kids now while I'm alive and make it easy on them so it's theirs when I die. That's a big mistake. Write that one down. Don't ever be tempted to do that. And if you hear someone doing that, don't do it. And unfortunately, clerks and recorders and different people, realtors, title companies, sometimes give legal advice when they're not supposed to. I know it frustrates us when we walk up to the window and they said, we can't give legal advice. It doesn't frustrate me anymore because I see what happens when they do give legal advice. They say, go to a form store and fill out this deed and you can do that. And oftentimes it's a bad idea. If you give away, if mom gives away her home to her kids, before she dies, that could be a big tax error. If she bought the home for $100,000 in 1970 and then dies and it's worth $1 million in 2022, if she keeps the home when she dies and it passes to the kids after her death, her kids will get what's called a stepped up basis, a tax basis of the value of the home when she dies. So if they sell it for approximately the same price, they won't have any capital gains tax. However, if she gives it to them before they die, and then they sell it for $1 million, they're paying capital gains on mom's basis, which was 100,000 when she purchased it, to the $1 million when they sell it. That's a huge capital gains payment that they had no idea they were stepping into by trying to make things easy on the kids after mom dies. So make sure you get tax advice and legal advice before taking any transfer of properties like that. Next slide. Revocable living trusts. That's a big issue. Do I need a revocable living trust to own my assets? Or am I okay owning them in my own name and just having wills and beneficiaries named on my assets for when I die? Frankly, there are biases both ways on this. There are attorneys who do quite well in promoting revocable living trusts in almost all situations. And there are others, and I have the bias of not jumping right to a revocable living trust, that think because we're a probate friendly state and because we have opportunities for naming beneficiaries, that creating a revocable living trust now to hold all my assets while I'm alive is not always the best and easiest and smartest way to go. So let's talk about some advantages or disadvantages to having a revocable living trust. The advantages was it can avoid probate if you fully fund it, which means you put all your assets into that trust. It can also be an advantage if you own maybe a home in Florida or in Arizona and a second home, and you want to avoid having to go through probate in other states. That is a good reason to have a revocable living trust. I say it avoids probate. Well, sometimes it does, and I think most times it probably doesn't. And the reason why is because you start off with good intentions, you create this expensive trust, and then you don't fully fund it. Or you sell your home that's in the trust, and you buy a new home and you don't put it in the trust, and then you die. So most people that I've come across don't fully fund their trusts. And so if they have formed it for the purpose of avoiding probate, they have failed in what their goal was. Another advantage is helping with management of assets while living. If a person gets Alzheimer's or really needs help in managing their assets, there can be an advantage to having a trust own those with a trustee that's not the spouse that's got the problem or the mom that's got the problem or the dad. Sometimes a trustee can more easily manage assets than using a power of attorney. Powers of attorney generally work pretty well, but that could be an advantage to a trust. There may be some more privacy with a trust than with wills, but I haven't seen privacy as an issue either when someone's alive or after they die in my practice. A myth. People think if I have a revocable living trust, it protects me from creditors. Well, if you have a revocable living trust, you control the whole trust. And if you control the whole trust, then creditors aren't prohibited from coming after you or your trust if they have a judgment against you or a claim against you. So that would be a myth. They have tax advantages. They don't have tax advantages. Earlier in our conversation, we were talking about trusts that we may set up in wills for the purpose of lowering or eliminating federal estate tax. That concept of creating trusts to avoid taxes can be present in both a revocable living trust or in your will document. So just having a revocable living trust does not help with eliminating or lowering taxes. Disadvantages. They're usually more costly to set up. I would say that a will package will probably run you somewhere from $1,200 to a couple of $1,000. A trust package will run you somewhere from $2,500 to $5,000 around town, if that's what. So there is more of a cost to set up, to fund, and to administer. So if you set up a trust, you have to then do a deed from your home to the trust. If you refinance your home, they usually require that you do a deed from your trust back to yourselves, take out your loan and put.
John, can you see everything? Are we coming through here?
Yep, we're good. You guys can continue on. Thank you.
All right, very good. All right, so did we leave off at the cost? Is that when you last heard us, John?
Yeah, that's right. Right at the end there, and then getting into some of the complexity question.
Okay. So they're more complicated, is that, I think, the last thing I heard.
Yeah, they're more complicated. I don't know if you heard that. I mean, mentioned that oftentimes people show up with their big binder of trust documents and they really don't understand them, and they find that unsettling. And so sometimes it's good to keep those in place. Other times it's good to simplify. And sometimes simplifying when you get older are good things to do, and it can more easily be done because our estates are usually more simple as we get out of some of the more complex business deals or partnerships or different rental properties that we may have owned as we were younger, and the estate looks much more simple. I'm going to turn this over to Brian for the next group of documents.
All right, so I'll quickly touch on the ancillary documents that we do along with the will or trust, and hopefully leave a few minutes for questions here. So the first one we do is called the living will. And this is the pull the plug document. So this is the document that you need so that you get to decide how long you want to be kept alive on life support once you've had 2 doctors say that you're in a persistent vegetative state or you're in a terminal condition and you can't communicate for yourself. And so obviously we want to make sure that we're not putting pressure on our loved ones to have that make that decision for us. And ultimately what we're trying to avoid is people fighting over that, like the Terry Schiavo case, where you have parents and a spouse fighting over keeping you alive. So that's what we're trying to avoid. You also get to say if you want to be taken off artificial nutrition and hydration. We have some HIPAA language in there and some release language to allow people to talk to your doctors, and then organ donation. So that's an important document to have so that you are setting forth your wishes with respect to that end of life decision. The other one of the other documents you need is a medical durable power of attorney. And this is where you're appointing someone to make medical decisions for you if you can't. And so obviously this is a situation where you're incapacitated and you need a spouse or a child to make all kinds of decisions, whether it's what medications to give you, what surgery you need, long-term care, hospice decisions, all those kind of decisions. You want to pick the person that you want to do that. And if you don't have a medical power of attorney, you may have to go to court and get a guardian appointed for the person who's incapacitated. So that's why it's so important to have a medical. And then the final document is the financial power of attorney. And this one's really important. We use these all the time. And obviously this is when you need to appoint someone to sign financial documents for you. And there are a couple ways to do this. One is to make it effective immediately. So often with spouses, we will give power of attorney to the spouse so that they can go sign their name on legal documents if they're sick or they're out of the country. Or you can require a doctor's note for it to be effective. That's the other way to do it. It kind of weakens the document a little bit, but it provides protection that it can't be used until you're incapacitated. The powers of attorney are really powerful. They allow your agent to sign your name on deeds. That's why I put a house on there. They can access your bank accounts, but it's really important, especially if you develop Alzheimer's or dementia or you're incapacitated. You need someone to be able to make those decisions. And again, if you don't have this, then your interested parties would have to get a conservator appointed for you in order to make those decisions for you. So that's a reason why it's so important to do that. So those are the 3 power of attorney documents that we do. And then Steve will touch here on the last slide.
Okay, I see that we've gone a little long. We want to have questions, but this is called a letter of instruction. When people die, we want to avoid this artwork, The Scream by Edvard Munch. And people feel that way sometimes if you're not organized for your heirs. And a letter of instruction is something we can email to John or Steve that they could provide to all of you. This is a document you can customize, listing all of your assets, and it's very confidential. It would have PIN numbers and passwords, and I would put this with your estate planning documents so that your heirs would have access to know what you own and what your desires are for all of that. That's what we have. I think we can move to questions.
Well, thank you, gentlemen. We do have a couple of questions that came up. One was in regards to the annual gifting. The annual gifting limits that you mentioned for kids, but could you clarify that gifting limit is just for kids, or can that go to any family members or extended families, things like that?
Sure. There's no gifting limit to spouses. You can give an unlimited amount to a spouse. To any other person who is not a spouse, it is $16,000 per person per year. It can be a neighbor, it can be a child, doesn't matter. No limitation on gifting to charities
And
nonprofits.
And that gifting limit is effectively per person. So a married couple could give that amount to double that amount to one child. The husband could give 1/16, the wife could give 1/16.
That's true. And as I mentioned, also, if your spouse or your child is 16,000 to each son and daughter-in-law times 2.
Mm-hmm. Another question is in regards to well, a couple of things on the state delineation. So if you have a Colorado will and live out of state, is that effective? And said another way, if you live out of state, can you get a Colorado will, or is there any specification on state regulation or anything?
States do have different laws, and especially about probate. So you may be moving, if you're in Colorado and you have Colorado documents, you're moving out of state, I recommend always that you meet with an estate planning attorney in that state to see what document changes you may need. Maybe you need trusts in that state, maybe you don't. Maybe the living will is a different statutory setup, or I know our financial power of attorney requires certain things be in that power of attorney are applicable in our state. I know I did a power of attorney once and they moved to Louisiana, and I didn't have it witnessed because it's not required in Colorado. It is required in Louisiana, and so it was ineffective there. So those are the kind of things we want to avoid. Do out-of-state documents work here in Colorado? They often do, but we should look at them here just to see what they say and are they appropriate for our state.
Wonderful, wonderful. That's helpful. Another question was effectively on is a will enough in Colorado? And perhaps there's more detail on a personal level for if a will is enough to have for your documents in Colorado, or if you need something more.
If the question is with respect to a will versus a trust or other documents, oftentimes a will is enough, but a will is not enough if you don't have a living will or a financial power of attorney. Understand that powers of attorney work while you're alive, and when you die, they cease, they terminate, they're void, and the will takes over. So while you're alive, a will is not enough. You need powers of attorney.
Wonderful. And in some of the conversations that we always have with clients, we talk about estate documents and making sure that you have them, and the importance of a medical directive. That's usually the terminology that we use. Maybe you can educate us, Steve and I, a little bit on medical directive versus the medical durable power of attorney.
Sure. So medical directive is another term for the living will. So it's kind of interchangeable, but when you say medical directive, you're referring to the living will, which I described as being the pull the plug document. So that's where you set forth what your wishes are with respect to life support. So that's really important. And then also along the lines of a medical directive, you need an agent to make decisions for you.
And that's where the durable power of attorney would step in.
Yep, exactly.
Wonderful. In regards to paper documents versus digital, everybody's got an estate planning binder. They don't probably carry it around with them everywhere they go, thankfully. Can you speak to, is digital a good enough medium to hold your documents in, or are you required to have them in paper?
In Colorado, the original will is necessary to probate and to be accepted by the court. So you need to make sure that you keep the original will somewhere safe where the beneficiaries can find it or your personal representative can find it. The powers of attorney, the copies are effective as originals. So you can use a scanned copy of a power of attorney. So, obviously I know that with your folks, John, you guys have a vault the documents sent to so that they can have digital access to those documents. And that's great. The only thing to keep in mind is you do want to make sure that you keep that original will safe.
Great, great. Well, that pretty much covers most of the questions that we've been fielding in from the chat. If anybody has anything else in the next moment or so, feel free to tag me on the Zoom chat and I'll field that up to Steve and Brian. In the meantime, thank you, gentlemen, for your time today. A reminder for all of our attendees, like Brian mentioned, we do offer for our clients within Wealth Vision to hold those documents, especially those in case of emergency type documents, the medical durable power of attorney, the living will, the medical directive, things like that. We would put those digitized in your vault so that if something happens, you can call, you can get a hold of us by phone or on the weekend, and we can get that to you urgently. Like Brian said, will that happens after death, so it has a little less urgency in a crunch time moment, but that's something that we want to make sure you have. You could also do that on your own with some form of digital storage, but that's something that we always make sure clients have.
Hi, John, I see one there that, just to confirm, in Colorado, a will is enough and a trust is not necessary. I would say yes, that's true. In most circumstances, a will is enough and a trust is not necessary. But it's worth looking at your specific situation to.
Wonderful, wonderful. Yeah, that's probably a very situational basis depending on needs of the family and other variables that are in play there. This webinar is recorded. We will be able to make that link available to you. Feel free to rewatch if you need any further information, or if you missed something on your notes. Feel free to share it and pass it along to friends and family. Like Steve mentioned, if your kids need to do something like this, maybe getting them in front of a presentation might be helpful for it. So thank you, gentlemen, for your time today. Thank you all of our attendees for investing part of your afternoon with us. We hope that this was a valuable bit of your time on a topic that isn't always the most exciting thing in the world, but we wanted to make it clear and concise and just give you that information that you needed to know. So we'll wrap up from here. Again, thank you all for your time, and we hope you have a wonderful day.
Thank you. Thanks, John.
Thanks.
Take care, everyone.